Good afternoon again, everybody. Okay, we'll make a slow start and get cracking. Welcome, and thank you very much for joining us. We haven't done a webinar, I think, since the beginning of the year with renewals and such like, taking up a lot of time for everybody. This is the first one since January, I think. So thank you for joining us. Couple of quick house rules. If possible, could you stay on mute, please, because it gives us a lot of background noise and echo for people and disrupts the quality of for everybody if we don't. There is a chat function. You'll see a little speech bubble at the top of the screen there. You can type any questions you may have in there, or we can wait till the end. There's a questions section at the end. Feel free to ask them as you go through as well if you so wish. As interactive as you wish it to be. We are recording this as well for your information. So once we're finished, we will send a copy of the recording once we've edited it nicely with logos and such likes at the beginning and the end. We'll send a copy of that out to everybody that registered. Hopefully you can see the slides, and we'll make a start first by introducing the panel. Many of you will know Holly already. Holly Hughes is one of our claims executives. She is based in the Newcastle office, but deals with our Greek membership. So hopefully, if you have met up or spoken to Holly, I know she's been out to Greece and spends a couple of weeks when we were allowed to in the glory days. And hopefully soon everything will calm down and you'll be able to see Holly face to face again out there in your offices. Everybody should know Costas, works in our Piraeus office, senior claims executive. Always a pleasure to work with, and I'm sure all of you know him very well. I am merely here to flick the slides over today. I'm a master mariner and loss prevention executive, so an ex-seafarer. I don't handle claims, just the technical side of things entirely. So I'm hoping to get as much from this as everybody else. With the excellent personal injury team that we have at our disposal. I have, however, spent a lot of time sailing with Filipino crew. From when I was a cadet, really, it used to be full British ship on British flag, and then the British ABs were got rid of, and Filipinos were brought in the early days of my career. And that has grown and grown and grown throughout the time to approximately last year 380,000 Filipino seafarers, and they do have, as it says there, a fairly unique combination of dedication and discipline, and of course the economic payback of sailing with Filipinos. I mean, I would never have dreamt of doing 9 months to a year trips for a start, but these guys do that all the time. And I think you look at that list of things that you have there, particularly dedication, discipline, and that last one, loyalty. And I think that we can recognise and say that is true. But it does take input from our side as a company to harness that. As with any nationality, if we don't treat them right, then we don't quite get the payback that's deserved. So certainly, they're very hardworking and loyal if they're treated in the correct manner by the company in which they're working for. The numbers have grown, and so have the colleges, and about 80 to 100 maritime training colleges over in the Philippines, which is a lot considering the UK. There's sort of 3 or 4 main ones. And at the beginning of any intake, 80,000 to 100,000 will enroll. Only about 15,000 of those will complete through either not being good enough to make the grade or couldn't find sponsorship in the time. And STCW, so they get a certificate of equivalent competency if they're an officer, and all that training counts. It's a slightly different structure to some of the European countries. I think they only do sort of 1 12-month trip, whereas I did sort of multiple 3-4 month trips, and so slightly different in that respect. But all in all, I think the payback from Filipinos is excellent for shipping companies. They are, however, prone to be slightly hypochondria sometimes. I know we used to hand out a lot more paracetamols when I was working as chief mate with Filipinos than I did with the Europeans. Those 6 there currently over the last year have made up between 35 and 40% of all illness claims for Filipinos. And I think most of you that are working in crewing or in a shipping company will have certainly come across at least one, if not more, of those. So particularly back, a lot of them, the vast majority of them are made up of sort of engineers and deck crowd. So there's a lot of manual handling problems. And that's the kind of illness we're hoping to avoid with schedules in the PEMI schemes and things like that. Obviously, the amount of these and different illnesses fluctuate in time. So later on, the guys from the personal injury team will talk about our PEMI and how that also changes depending on the situation at the time. So that's enough from me, because as I said earlier, really I'm only here to listen in as well, help these guys out with changing the slides over. It's about as technical as it gets to me. So I'm going to hand over to Costas and Holly to talk about the different kinds of contracts and the comparisons and benefits between these different contracts. So Costas, do you want to unmute yourself and let us hear you?
Hello, good afternoon, everybody, and welcome to North's first personal injury webinar. We hope it's the first of many. I hope you like it. Right, why Filipinos? John's already mentioned the whys. Now, what's peculiar about the jurisdiction? And why Filipinos and why the Philippines? I think number one is the peculiarity of the jurisdiction. It's rare for Filipinos to file claims abroad. I'm not saying they don't, and they never have done. Those older amongst us will remember there were a lot of ship arrests back in the mid to late 1990s in the Panama Canal, which were eventually thrown out in favor of the Filipino jurisdiction. Again, Filipinos can claim and do claim in the United States. Greece, where we all know that the courts are open to claims from foreign seafarers. In the 25 years I've been doing personal injury claims, I've only ever seen 2 Filipino claims before the local courts. Now, any of you who employ Ukrainians and Russians may have actually faced and handled claims before the POEA courts with for Ukrainian and Russian seafarers. That doesn't really happen with the Filipinos, and I'll tell you why. Why? Because it's a ready-made system for them. They don't really need to do anything. If they decided to claim abroad, then they would probably have to pay for a Filipino lawyer as well as a foreign lawyer. It's a ready-made system and jurisdiction for them. They also don't need to arrest a ship for security once they file a claim. What security do they have? Well, they can enforce their judgment or any award in their favor by simply garnishing a manning agent's funds. Anybody that has dealt with Filipino seafarers for a long time knows that the manning agents over there, in order to have a license, must file a bank guarantee with the Filipino authorities. They will lose that license and the bank guarantee if they do not, if they allow an award to go ahead unsatisfied. So, furthermore, it's seafarer friendly, like with a lot of jurisdictions. It's even more specific in the Philippines because Article 4 of the Filipino Labor Code specifically states all doubts in the implementation and interpretation of the provisions of this code, including its implementing rules and regulations, shall be resolved in favor of labor, so in favor of employees or seafarers. The POEA, or Philippines Overseas Employment Administration, was established in 1982 to promote and monitor the overseas employment of Filipino workers. Filipino seafarers are just a fraction of the overseas Filipino workforce. The POEA SEA, or POEA Seafarers Employment Agreement, is the standard industry contract. Its terms are well known. I'll just go through some of the more popular ones. Number one is work relation. All illnesses must be work related in order to give rise to sickness wages, medical treatment, and where it leads to disability compensation. There's a ready-made list of occupational diseases in section 32A of the POEA contract. Now, this is not a definitive guide, sorry, not a definitive list, it's only a guide. What that means is section 20, paragraph 4 of the POEA contract states, those illnesses not listed are disputably presumed as work-related. Again, remember, Article 4 of the Labour Code. If there's any question, the courts will probably look to supporting Labour or the seafarers. Again, there's a range of disability gradings from grade 14 disability, which will give rise to compensation of $1,870 all the way up to grade 1 disability, which is $60,000. Again, another one, ready-made death compensation of $50,000 and $7,000 for each child, up to a maximum of 4. Also, there's a 3-day reporting limit. Means when a seafarer arrives back home after having been discharged because of an illness or injury, they must report within 3 days at the local manning agency. The POEA, however, are the minimum benefits available to Filipino seafarers. These can be enhanced by use of a collective bargaining agreement, or CBA. So I'll now pass you over to my capable colleague, Holly, to talk about CBAs.
Thank you, Costa, and hi, everyone. When we refer to the conditional bargaining agreement, which is the CBA, that is often an agreement which runs alongside the seafarers' POEA agreement. The most common we're seeing in the Greek market at the moment are the Cyprus CBA and also the ITF-IBF agreement and the PNO-TCC. We often find that the CBA will be of a greater benefit to a seafarer. One of the biggest differences will be the fact that there is no requirement for an illness or injury to be work-related for the seafarer to be entitled to its benefits. The contract of employment itself should indicate whether there is an overriding CBA and identify which CBA that is. We do see in some cases that a POEA agreement at the section that states CBA will say none, but members have a different ITF or MLC agreement which will specify the CBA. It's very helpful for us as your club from the outset to have access to all of the seafarers' employment contracts, but also that CBA, so we can review that and assist you in identifying what your obligations are to your seafarer. So now what we'll do is we'll look at the benefits under both the CBA and the POEA and how they compare to one another. So dealing with the POEA first. Under the POEA, as Costas has said, there is a requirement that any illness or injury should be work-related for the seafarer to receive the appropriate benefits that are set out in the POEA terms and conditions. In addition, as Costas said, the disability will be determined, so the work relation will be assessed in accordance with section 32A, and any that are not listed are disputably presumed as work-related. In the event that your seafarer has an illness or injury which is work-related, they will be entitled to receive their illness allowance or their sick wages until they are fit, or to a maximum of 120 days. We should also say that if the seafarer has concluded their contract on board, they have been repatriated but referred to their manning agents within the 3-day reporting requirement, reporting an illness or injury, they may not be entitled to receive their illness allowance or sick wages. The reason for this being they've concluded their contract and there isn't actually any loss of income on their part. In terms of medical treatment, this will be provided until they are fit or until they are determined as disabled by the company doctor in accordance with section 32. The disability, if any, that is awarded by the company doctor is awarded as a grading, which then corresponds to a percentage and is multiplied by $50,000, confirming the sum due to the seafarer. For example, the loss of a big toe is a grade 12. This corresponds to a percentage of 10.45. When multiplied by $50,000, this results in a payment of $5,225. Compared with a grade 1, which is also a permanent and total disability, such as total blindness, This will be calculated at 120%, which is then multiplied by $50,000, resulting in a payment of $60,000. If the seafarer disagrees with the company doctor, and as we all know, they do that very often, they have the ability to appoint their own doctor. If that doctor disagrees with the company doctor, which again, we know they always do, a third doctor may be agreed jointly between the employer and the seafarer. Once that examination has taken place, that doctor's opinion will then be final and binding upon all of the parties. Should a crew member sadly die during the course of their employment with the members, the death must be work-related, and then if that is the case, the crew member's heirs are entitled to receive $50,000 plus additional amounts of $7,000 per child under the age of 21, which is capped at 4 children, and a burial allowance of $1,000. Also, just like to point out that in the POEA, if a crew member is hospitalised for at least 7 days, then they are entitled to have a family member or requested individual visit them on a compassionate ground. The employer is to pay the transportation cost to the nearest major airport. However, should there be any visa requirements or travel document requirements, that would be at the responsibility of the family member or requested individual. Turning to the CBA, there are some differences. The differences mainly come in terms of work relation and the amounts due to the seafarer in the event of disability or death. One of the biggest differences, as mentioned, is the fact that an illness or injury does not need to be work related for the seafarer to be afforded of the benefits under the CBA. If a seafarer is sick from illness, they will be entitled to 130 days of sickness wages. I'd also say that this is on the basis of an ITF contract. It's important to check your own CBA or allow the club to check the CBA to see what the specific entitlements of the seafarer are in each individual claim, but we mostly see it's 130 days or 120 days under the Cyprus CBA. If the seafarer has been repatriated due to injury, the CBA often allows for sickness wages until fit or medical determination is made regarding permanent disability. There's a similar provision for medical treatment where illness allows for treatment for 130 days after repatriation, or for injury, again until fit or medical determination is made regarding disability. For the permanent disability under a CBA to be awarded, there is a requirement that it is as a result of an accident, regardless of fault, and that it reduces the seafarer's ability to work as a seafarer. The company doctor will then decide in accordance with the agreement, and we often see that there are annexes which detail different gradings in respect of different illness, different injuries. In a CBA, the loss of a big toe would be a 5% disability, whereas loss of sight would be 100% disability. We also see that there are differences for rank that we do not see in the POEA. For ratings, it would be $104,866. For a junior officer, $139,820. And for a senior officer, which is most often the master, chief officer, chief engineer, and the first engineer, $174,775. So it can get quite costly when you're talking about your officers. There are again similarities should the seafarer disagree with the company doctor in that they can appoint their own, and if there's a disagreement, refer to the third doctor whose decision is final and binding. CBAs also often have an unfitness for work clause where a seafarer who has a 50% or more disability is regarded as permanently unfit. So a 60% disability under a CBA would result in an entitlement to receive 100% compensation. Or if they have a disability of 50% or less, but they remain permanently unfit to go to sea, they are also entitled to 100% compensation. In the event of a death, compensation is payable for death due to any cause, including natural causes. There is no requirement for a work-related death. In the event of a death, current compensation under an ITF agreement is $104,866 plus US dollars of $20,974 for each dependent child under the age of 18 to a maximum of 4 children. The employer is also responsible for the cost of burial expenses, but this is not specified as it is in the POEA at $1,000. Where the benefits afforded to the seafarer between the POEA and the CBA differ, which is often the case with the CBA providing the greater benefits, the seafarer will always be entitled to the greater benefits between the two. And then I think I'll hand to Costas next.
Thank you, Holly. So the NLRC, or National Labour Relations Commission, these are where any disputes under the POEA are discussed and awards are made. This is compulsory arbitration, so disputes must go there under the POEA Seafarers Employment Agreement. There we have claims for actual, moral, exemplary and other forms of damages arising from employer-employee relations. So it's not just illnesses and injuries, it's also unfair dismissals or alleged unfair dismissals, and so on and so forth. There's a set of procedures, and there is an appeal process that goes along with it. As I said, the arbitration here, it's compulsory. Any claims, we start off with the so-called single entry approach, or SENA for short, which is where claims are effectively discussed, and if a solution can be found, it will be settled there and then. It's actually quite rare in my experience for claims to be settled at SENA level. Again, that's just my own personal experience. I'm not saying it doesn't happen and hasn't happened. So what happens once the SENA approach fails? Well, we then proceed to a labour arbiter, or LA, which is one person, who will review both parties' submissions and eventually make an award. If the award is, for instance, against owners or employers, we then have 10 days within which to appeal. And in order to appeal, one must file an insurance bond, or a club LOU will be required, which can be posted to the local insurance company to issue the bond. The appeal will then go to a full commission of the NLRC, where again the claim will be discussed. Once, in the event that an award is again made against owners or employers, we can then appeal again by way of a motion for reconsideration, and this will take it to a higher court. If that is denied, then what normally happens there will be a motion for execution filed by the winning party, unless we are able to obtain a temporary restraining order. Now, this is very rare. I think, again, in 25 years, I've only ever had 2 or 3 maximum which have been issued. It's rare. Once a motion for reconsideration is denied and a temporary restraining order is denied and a motion for execution is awarded, we then go to a writ of execution or garnishment. Remember when I talked about a manning agent's funds being garnished? Which this will mean an execution of the award against those funds, whether it's the owners or club by extension paying, or in rare circumstances the manning agent having to pay. It's a very difficult subject to talk about because the last statistics the International Group of P&I Clubs has is that there are between 35 and 40 million US dollars of owners' funds, owners and clubs' funds outstanding, due back to owners and clubs for cases where appeals have been won. It's an uphill process. It's not easy once funds have been paid over to a seafarer to get them back on appeal. The other thing we've seen recently, as most of you have as well, is even where owners win, sometimes there are so-called humanitarian awards made. This is, in the interest of humanity, and the sums can vary between $1,000 to $5,000. Some of our colleagues in Newcastle and the other club offices have faced awards of up to $10,000. Again, you can appeal those, but I suppose they're playing the numbers game, i.e. how much do you want to pay your lawyers to fight this? That's as far as the POEA SEA is concerned. When you have a collective bargaining agreement, or CBA, you have the chance to file your claim before the National Conciliation and Mediation Board, or NCMB. The difference is this is voluntary arbitration. Seafarers don't have to go there. They can continue with their claim, even if they have a CBA, with the NLRC. What happens here? Well, rather than have labour arbiters, we have conciliator mediators, or voluntary arbitrators. These can be specifically named in the collective bargaining agreement, which is rare in my experience. There can be a selection clause or provisions in the collective bargaining agreement, again, rare from what I've seen in the Greek market, or, as quite normally, what normally happens is parties will submit their preferences via their lawyers or choices, or, worst comes to worst, the NCMB itself shall appoint them. Now, what is the big difference? Well, apart from it being voluntary arbitration and voluntary arbitrators and mediators, the other big difference is, unfortunately, our experience shows that the NCMB is heavily, and I repeat, heavily weighted against ship owners and employers. One Filipino Correspondent statistics shows that only 10% of awards are made in favor of ship owners. I'm not saying don't try. I have had positive awards, and I think the tide may be changing. However, the big problem with the NCMB arbitrators and mediators is threefold. Number one, very few of them are actual lawyers or have had legal training. Very few of them have any experience of the marine industry. Very few of them are ex-seafarers. So the way they look at it is they commonly disregard the law in favor of, quote unquote, supporting labor or making humanitarian awards. Remember, Article 4 of the Filipino Labor Code. It shall be found in favor of labor. With that aside, I'll pass you back to Holly again to talk about numbers and 120 days.
Thanks, Costa. So, as confirmed earlier, the POEA provides for medical treatment to be provided in cases of work-related illness or injury until the seafarer is either fit or until the company doctor has made a decision regarding disability. There is no specified time limit prescribed in the POEA for treatment to be provided, unlike the provision for sick wages, which we know is until fit or to a maximum of 120 days. However, in 2005, the Philippine Supreme Court ruled that the seafarers were subject to the Labour Code and their concept of permanent disability. So this meant total and permanent disability was for any illness or injury which lasted for more than 120 days. This was terribly concerning, as you can imagine, this resulted in any seafarer who had the inability to perform their customary work for more than 120 days being awarded total and permanent disability benefits, either under the POEA at the limits we discussed earlier, or alternatively seeing them get much higher awards under their overriding CBAs. In 2008, this decision was again modified by the Supreme Court, which extended that period of treatment to 240 days. Interestingly, the 2010 POEA states at section 20.A.6 that disability shall be based solely on disability gradings provided under Section 32 of this contract and not be measured or determined by the number of days a seafarer is under treatment or the number of days in which sickness allowance is paid. There have been different cases since, which have seen slightly different decisions, and while some of the courts have ruled on the previous 120 days, it's more recently been on the 240 days. However, what we can see from this is that the court is absolutely fixated on counting the number of days of treatment rather than the provisions that are actually laid down in the POEA itself. 120 days is a very important milestone. The company doctor at that time should be determining whether the seafarer is fit, whether they require further treatment, or whether a disability grading should be awarded. If the seafarer requires more treatment, then the period of treatment may be extended for a further 120 days up to that 240 days. The 240-day deadline, remembering the court's absolute fixation on the days of treatment, is an extremely important deadline. There should be a clear decision by the company doctor well before 240 days to give the agents time to discuss with the seafarer the findings of the company doctor, the conclusion they've reached, and what will happen next before that 240 days. The company doctor should be making a decision as to whether the crew member is now fit or whether they've reached maximum medical improvement and what any ongoing disability will be, if any. And that should be done in accordance with Section 32 of the POEA. anything over 240 days would be considered by the court as total and permanent disability. So we really have to be careful when we're getting to that time period when a crew member is still receiving treatment. Once the decision has been made by the company doctor, this must be delivered to the seafarer. This was recently established in the case of Gear and Anglo-Eastern, where it was said that if a seafarer is not personally furnished with either his fitness certificate or his disability grading within that 240-day period, then it's as if he was not provided it at all. So the lesson from this is to be very aware of both 120 days and 240 days when the crew member is under medical treatment, and work with the manning agents and the company doctor in that respect. Now hand back over to Costas.
I just have a quick question while I'm in there, Holly. I've listened in, you've had sort of 3-day limits, 120 days, 240 days. There's lots and lots of sort of references to timeframes throughout nearly every slide that we've had from you and Costas. I think, is it safe to say, therefore, that really it's hugely important that the members let you guys know with ASAP with any potential claim, not wait until it starts to unfold a little bit further down the line, but if there's an inkling of a potential of a claim coming, let you know, and that early warning for you guys is important.
Yeah, definitely. I mean, not every illness or injury is going to result in a claim, and we certainly wouldn't want to be approaching it from that negative point of view, but the difficulty is with the way the courts are stacked against the ship owners already. The ambulance chasing lawyers we have in the Philippines as well. I've heard instances of them hanging around in hospital corridors, outside manning agents' offices. So they are ready to get those claims all of the time and push the seafarer to do that. So it is really important that we're notified not to run the claim or tell the members how to do their jobs or anything like that, because we know everyone in this meeting knows exactly what they're doing. They know how to deal with their crew. They know exactly how to run things day to day, but just to assist in keeping that eye on it, because if it goes over that 240 days, it can be catastrophic. You can have a crew member who had a grade 10 disability at $10,075 suddenly be entitled to, he's had an accident, he's entitled to $104,000 under his CBA. So that's the difficulty that members are facing at the moment. And I think when you have a lot of crew and a lot of things going on, just that one date can slip away from you, unfortunately, and see a claim cost a lot more money than it should, really.
Okay, thank you. Cheers. Thanks, Costas. Sorry to butt in.
No, always welcome. I would completely agree with whatever Holly says. It's better to let us know. I know some members say, well, we didn't think it would be above deductible or not, but I would rather know at the early stage and have more files opened rather than not know and suddenly have a surprise, as I think most members would as well. Advice, well, number one, let's start off with the PEMI, pre-engagement medical examination. You all know that one is required before a seafarer can go on board a ship. Now, common sense, an old saying, prevention is better than the cure. There are thousands of clinics in Manila and the Philippines in general. There are many ready-made, off-the-shelf PEMIs which could be bought on the street, or so we're told. But even generally, PEMIs from good clinics, they can vary in quality even from the same clinic. It really depends on what you as a company or your manning agent or your local office by extension is able to arrange with the clinics and the doctors there. Now, North, together with a lot of the most other clubs in the international group, run its own PEMI scheme. What makes North's different and unique is the way we operate it. It's we constantly keep it monitored, not just the clinics themselves, but also the latest illnesses and conditions. I'll talk about that in due course. Now, we have arrangements with 5 companies. In Manila, they are SM Lazo Medical Clinic, Halcyon Marine Healthcare Systems, Maritime Medical and Laboratory Clinic, and Supercare Medical Services. Supercare also have clinics in Cebu and Iloilo. We have another clinic, Physicians Diagnostic Center, who, although have a clinic in Manila, our scheme only operates in their Cebu clinic. It's split between seafarers up to the age of 41 and seafarers above the age of 41. The cost of a PEMI, the North PEMI, for 40-year-olds, sorry, people up to the age of 40 is $85. And for those 41 years old and above, it's $120, which will include a mandatory stress and cardio test. Those older colleagues or people who've been in the business longer will remember we used to split it between 3 separate age groups. We found it's better to split it into 2. As I say, we keep monitoring illnesses and conditions. Anybody who deals with Filipino seafarers knows that they are very prone to hypertension and diabetes. It comes from their diet and also their culture. Also, we keep hold of our statistics. So for the 2020 figures, the rejection rate was about 0.69%. Those were PEMIs that went before the North mandated medical scheme with the North mandated pre-engagement medical examination report. Now, pending referral figures, again for 2020, these were about 21.4%, usually due to the failure to return for revaluation after a recommendation to carry out additional treatment. As I say, they're constantly monitored, so they're updated. I've already talked about how we've changed the age splits for 3 age groups into 2. Certainly at the start of the scheme, we had simple blood sugar tests via urine and blood. That was modernized in favor of the HbA1c, which shows long-term blood sugar levels. These can't be cheated. It will show the blood sugar levels of the previous 3 months. How else do we monitor them? Well, they're audited at least once a year by staff from our Newcastle office. Holly and our colleagues, Abby Rudd and Lucy Dixon, together with Dr. Charlie Eastman of Your Excellent Health Service clinic in Harley Street, London. They fly over and they visit all the North PEMI scheme clinics. They speak with the doctors there. They also speak with Dr. Glenda Canlas, who manages the Halcyon Marine Healthcare Systems. She also monitors and manages the PEMI scheme for North. There are meetings once the North team is over in Manila with all the heads of the clinics, and they discuss common issues and so on and so forth. It's a closed list of clinics. We currently have no plans to expand it because we feel we can offer the best service and the best quality of system if we keep the list closed and we keep it to 6 or 7 clinics. Having said that, it is a tough system, and it's tough for a reason. So you don't have people who go on board the ship who shouldn't be on board your ship. However, we do recognize that it's tough to find and retain good crew. So what we've done is we've created a concession agreement for returning seafarers. So not new seafarers. We want these to be people you know and like and will like to retain. And if these people, as I said, they're returning, you know them, and they either have hypertension or diabetes. When I say diabetes, I mean type 2 diabetes, not type 1 insulin-dependent diabetes. If they have either of these 2 symptoms, illnesses, and these can be controlled by medication to an acceptable level, then we will allow you to employ the seafarer. Sorry, let me rephrase that. Not allow you to employ the seafarer, but recommend that you can take this person on as long as they sign the concession agreement. Now, at the end of North's PEMI circular, you'll see a ready-made concession agreement. It's not been tested legally to its full extent, and it probably wouldn't hold up in the Filipino court system or at the either NCMB or NLRC level. However, it does make the seafarer responsible, or tell him or her that they are responsible for their own health. They are responsible for ensuring they have enough medication for the duration of the contract. And we always recommend they have a bit more, say 20% more, just in case their contract gets extended.
Currently quite possible, I imagine.
Well, as we all know from, yes, what happened after during the last year or so, more than a year actually, with COVID-19, unfortunately, many contracts have been extended, or time on board, a cruise time on board has been extended. So, for instance, with hypertension, we can see, can it be controlled with medication prior to embarkation? Yes. Now, an electrocardiogram must be normal. Any findings in an ECG or electrocardiogram must be cleared by a cardiologist. Additionally, we'll ask for a stress test and a 2D echo test as well. We also look at other factors or risk factors such as body mass index or BMI. So if somebody's obese, that you must alter your diet, reduce your weight, so you're able to join the ship. Again, if they have additional cholesterol and LDL levels, we can recommend that medications are prescribed to those seafarers to lower those and keep them under control. Diabetes, again, have to be rehired crew, not new crew. Candidates who are known diabetic, and despite the medication, have seriously elevated and uncontrolled levels, should be referred to an endocrinologist for assessment of possible complications and for clearance. As I said, we are there to assist. We understand there's a manning crisis. We understand that it's difficult to find and retain good crews. So we believe that with the use of concession agreements and using Dr. Charlie Easman to review these for you, we're able to assist you in this process. So you keep good crew. And even if they have ongoing conditions, not illnesses, such as diabetes and hypertension, you can continue to keep them as crew, but these are under control. We all know it's like with Greek seafarers. We know the majority of elder Greek seafarers will be obese or have high cholesterol levels or even be diabetic. It's just the nature of the industry. And with that in mind, I will pass back to Holly to talk about North's post-repatriation medical scheme.
Thank you, Costa. So the Post-repatriation medical program, or the PRM, was introduced by the club in February 2013. The aim of this was to provide efficient and high quality treatment for Filipino seafarers, alongside avoiding unnecessary treatment or cost for medical conditions which our members are not legally or contractually responsible for. The two clinics that we have are Ship to Shore and Ship Health. The programme works at its very best when the club is notified of the incident prior to the seafarer's repatriation. That will give us sufficient time to put arrangements in place and ensure that the seafarer is referred to one of those clinics. The seafarer is then able to receive his consultation and any ongoing treatment at one of the recommended facilities. If our members wish to use the PRM, please inform your manning agent who can assist in making the arrangements. Updates will then be forthcoming from the clinic, and they will assist in ensuring that the seafarer is also receiving their sick wages in accordance with their entitlements. It is also helpful for the club to be aware of the crew member's contract and whether there is a CBA, so that we are also aware of the members' contractual obligations and can assist in advising in this respect. Under the programme, it has been decided that on the medical reports, the phrase fit for work will not be used. Instead, the phrase fit for the condition referred as per the POEA contract will be used instead. The PRM doctors are therefore able to work on treating those conditions which have resulted in the repatriation of the seafarer, rather than any conditions that are incidental and have been raised since repatriation and have nothing to do with the repatriation itself. Those conditions are not what members are responsible for covering medical treatment for or providing sickness wages for. In addition, this assists in avoiding any claims from crew members when they proceed to have their PEMI and they fail for a condition which again is completely unrelated to the condition for which they were repatriated. In order to protect members' interests further, and again having an eye on those deadlines, if the illness or injury is lengthy, a report on the prognosis will be issued at 90 days, which is well in advance of the first 120 days. At the present time, our data shows that treatment in a PRM clinic before fitness for the condition referred is 35.5 days, compared with non-PRM clinics, which is currently at 97.1 days. We have seen in some cases that a seafarer has been initially treated at a non-PRM clinic. They've then, after fitness for work has been determined, complained of ongoing symptoms and have been referred to a PRM clinic. who have then carried out appropriate testing and found that the seafarer is actually still suffering from issues related to the repatriation and does require further treatment. One of the issues in this respect is the delay could result in the seafarer's overall prognosis changing, potentially disability compensation being due that wouldn't have been due had they been referred from the outset, or going over the 240 days, which we know now is crucial. If members do wish to use their own clinics, which we understand comes down to preference, commercial relationships, or any reason at all, what we would recommend you do is you audit your own clinics. Just ensure that they are doing what they need to be doing, that you're happy with their performance, and perhaps introduce a second clinic so you can do a bit of benchmarking there and see how the clinics are getting on in terms of treatment provided. Should members have any questions about the PRM or indeed the PEMI, which Costas discussed earlier, you can email our colleagues Lucy Dixon or Abby Rudd in the Newcastle office. For PEMI, it's pemi@netbeer.com, or for the PRM, it's prm@netbeer.com, and they'd be more than happy to answer any of your queries. If alternatively you'd rather discuss them with Costas and myself, email us, and if there's anything further we need to discuss with Abby or Lucy, we certainly can do. That's not a problem.
Excellent. So to be fair, just like my last question when I was talking about timeframes, then is it also fair to say that on an event of a potential claim due to repatriation for illness or injury, the PRM should be considered pretty much every time, be that the North one or the member zone?
Yeah, I would say so. It's good practice to have where the seafarer has either been repatriated due to illness or injury, or indeed refers to an illness or injury when they arrive home after completion of their contract, medically assessed in the best place for them. Not only does it show dedication on members' part for getting the crew member the right treatment, but from our view in the PRM, it just assists in the crew member not raising other injuries or ailments and going off on a tangent and getting treatment for things that have got absolutely nothing to do with the reason for their repatriation, which we sometimes see with things like hypertension and diabetes. Yes, they may have those conditions, but it's not the reason they've got a broken leg, for example.
Yeah. No, I think that's fair enough. When I talk about this, sometimes when we're with members, I always feel a bit mercenary saying that we're going to PRM to protect just the member, but it is quite important that not everybody is ambulance chasing. Some of them just need the right attention.
Yeah,
to shorten it out. Yeah. Sorry. Anyway, Costas, I think you were moving on to correspondence.
Yes, correspondence. Again, it goes back to what John talked about in the first question you raised, which is early notice. We've talked about the days, 3 days, 120 days, 240 days. We need to be on top of those, both members and clubs and employers, so we don't let things run away and lead themselves either to voluntary arbitration or the NLRC and then lead to an award without us realizing. We have correspondence here on the slide. They're there for a reason. They are the club's eyes and ears on the ground. Better to have them rather than nobody, unless you have your own dedicated office there with people you absolutely trust and they have in-house lawyers and the like. It's better to use a correspondent. They don't have to be a commercial correspondent. They can be a Filipino lawyer. Often, obviously, if you have to go to the NLRC or find yourself before the NCMB, you will need a lawyer. Now, I'm not saying use them all the time. One should be judicious in their use of them. See how they fare. Sometimes, don't go directly to lawyers. Sometimes don't even go to a commercial correspondent. Don't go directly to a lawyer. The other thing we've seen lately, and we have done, both Holly, myself, as well as the rest of the personal injury team in Newcastle and in North's other offices, is the use of surveillance. So private investigators. Quite often there are what Filipino lawyers call malingerers, i.e. people who really are fit for duty, but they can't be bothered. They would rather spin this out so they're able to get more sickness wages, and maybe even spin it out so they can breach 240 days and get their compensation. So with these malingerers, quite often what we do is we appoint a private investigator to go down around that person's house, see what they do during their day. So if they claim they've got a back problem, we'll see if they take their garbage cans out. We'll see if they go shopping to the market and carry sacks of potatoes. We'll see if they have another job ongoing. I don't want to be general and say people are stupid, but a lot of people don't realize they're being seen, or they can be seen. They don't realize that once you're outside your own house, you can be a target. So it's not just, private investigators aren't just used in the United States. They are used in the Philippines, and they can be effective. I'm not saying they're a guarantee, but as I said, you can get rid of malingerers, or you can embarrass a seafarer into coming to a commercial settlement rather than go ahead, at a lower level than he was expecting, or you might be expected to settle at. What other advice would we have, apart from keeping a look on time, is, as far as possible, be close to your seafarers. If you're lucky enough to have a Manila office, fantastic. If not, be close to your manning agents as well. If you're able to travel to Manila, do so. See what the culture's like. See your manning agents. Audit your manning agents. Audit the clinics. Make people aware that you're interested and you're aware. And if at all possible, build up a pool of seafarers. I know it's easier said than done, but make people want to join your company and want to stay at your company. Again, this goes on to another subject, another topic, which is a matter for another time, which John can talk to you about, such as the Right Crew program. So finding, retaining, and training the right crew. And I think that's enough on correspondence and general advice. John?
Thank you, Costas. So yes, there is further information available if you haven't already, and I know that we sometimes sound like a broken record on this one, but the My North account, a lot of the things that we used to have on public is now what we call premium content, and only our members can access it. So if you have a My North account, which will take you no more than a couple of minutes to activate, then you can get access to everything, including the two things there that you'll see, which is the pre-employment medical programs for the Philippines and the post-repatriation medical program briefing. Both of those are available online. However, as we've said, this has been recorded and we'll be sending you the video link. And when I do so, I will send you out those briefings as well for your interest. Any questions from anybody? Now, speak now. Yes, somebody's. Feel free to unmute and ask the question now if you wish. Go ahead, we can hear you.
Hello everybody.
Hi.
Yeah, Mr. Costas, Miss Coley, Mr. John, thank you for all the good things we heard. Actually, are you listening? Because I just unmuted.
Yes, we can hear you.
Okay. Don't you think that since 2005, the Supreme Court decision could be reconsidered somehow regarding the full disability compensation after prolonging treatments? We all understand that the claim of a Filipino is a ready-made industry, but especially this year of 2020, including 2021, we have seen from the PRM that there was a remote monitoring of the medical cases because few Filipinos were stranded in the provinces and they were not be able to come to Manila or to Cebu or to Iloilo to follow up with their treatment. So as a result, we had an automatically prolonging of the treatment. Don't you think that this mechanism, do you know any mechanism that we propose to our manning office, including to the ship to shore, to avoid prolonging treatments, especially in this COVID period? Because it's very easy, a small case to be prolonged, especially something that can be resolved immediately. I mean, about 60 or 65 days, but because of COVID, this is an automatically prolonged because of the COVID.
Jairus, thank you. Costas, Holly?
I would say, well, COVID, nobody could foresee COVID. Nobody could foresee the chaos it would wreak on not just the global economy, not just our personal lives, but also seafarers' standards. I quite honestly hoped that the local system would say, okay, the 120-day, 240-day limits will stop until, you know, the person is able to go to a clinic, or so on and so forth. Unfortunately, they didn't. We must always remember Article 4 of the Labour Code, that it will support the seafarer against an employer. It's unfortunate. It's the world we live in. It's the jurisdiction we're facing. Matters are improving, or well, we hope they're going to improve. We do know that there are various laws being drafted in the Philippines, one of which is ambulance chasing law, which will stop ambulance chasing lawyers, which Holly referred to, from going forward, or at least setting some limits on how they're able to perform and what they're able to do for their clients. There are various other things. What I didn't realize until I was in the Philippines, that pretty much every hospital ward in the Philippines has a bill of patient's rights. Sometimes the patient himself, the seafarer, is unaware of what his rights are. He is entitled to a copy of the medical report. Sometimes they don't choose to ask for it. They leave it in the hands of the manning agent. Sometimes the manning agent doesn't know they should send it on to the seafarer because the seafarer may not have received it. We can say with the employer or the ship owner. Apart from that, things are changing. I think they're changing very slowly. There was a 17-page letter drafted by the International Group of P&I Clubs to the Filipino authorities discussing the various issues that ship owners have with Filipino crew claim and what we don't like and what should be altered and amended. It's been done on an official level. Will they listen? Probably not. It can be political. I was aware 2 or 3 years ago that President Duterte of the Philippines had told commissioners at the NLRC that they are there to support labor. They must be seen to be supporting labor. So just imagine the president is telling judges, or well, not judges, but arbitrators what to do, how to resolve cases. It's not just Article 4, it's political. So, as I say, those are my Holly.
I believe the only solution, everybody, and the mechanism that we can propose to ourselves is just to chase case by case, not to avoid any prolonging of the treatment unnecessarily.
Absolutely, Harris. I mean, this is, you know, we talk about the time limit. We shouldn't forget the time limit. We should be on top of the clinics, on top of the seafarers, on top of the correspondents, so that these don't happen. You know, as I said, I talked about malingerers, but not just malingerers. Sometimes the time limit can run away, even when the seafarer doesn't want to. It can just get out of hand.
Okay, and I have one more question, if you don't mind.
Yeah, go ahead.
Okay. Although I may know the answer, we were discussing about NCMB and the volunteer arbitrators, which were ex-mariners. There was one effort from your P&I correspondents in Manila, especially as far as I know, Del Rosario was trying to have some intervention to all this ready-made industry of ex-mariners to be volunteer arbitrators. But of course, the COVID came, and I think that something stopped. Do you have any update about that? Do you know something further than us here in this seminar?
Costas?
Harris, I did mention before the 17-page letter sent by the international group, the NCMB was one of the topics in that letter. We do know, and I do remember Del Rosario had tried to say that if funds are awarded to seafarers at the NCMB, they don't go directly to the seafarer or his lawyer. They go to the treasurer of the NCMB, and then we're able to appeal without losing those funds. But unfortunately, it wasn't successful, or it hasn't happened in practice. I think we'll just have to wait when COVID finishes to try and start up again. We'll obviously speak with the correspondents. Matters, as far as I understand from correspondents in the Philippines and friends of mine who are in the Philippines and who do travel to the Philippines regularly, matters are changing so much so an acquaintance of mine, a correspondent, said that he will prefer now to fight claims before the NCMB rather than the NLRC. I found that surprising, since I prefer normally to fight claims before the NLRC, and there were more awards in favour of ship owners than there had been, say, 10 or 15 years ago. It's really dependent on luck and who you draw as an arbitrator, a conciliator, mediator. Holly, have you got anything else to add?
I think dealing with your first point, Harry, that question hasn't been tackled yet. It's probably a bit too soon. I think from my personal point of view, I've fortunately not had any claims go over that 240 days, even with COVID. And I think the efforts of the clinics and the agents has been phenomenal during this time to make sure that seafarers were kept in touch with and that treatment was ongoing as much as it possibly could be. And on the second point, I think the NCMB, what it is what it is, and we know it has its problems, and we know there are problems in the Philippines generally with corruption and other issues. So I think the takeaway from here is that we all know what we're dealing with together, and we can try and tackle those problems that are raised in the Philippines as a team, you know, in conjunction with your agents and the clinics and the correspondents out there, and hopefully try to get some favourable results on ourselves the best we can.
Great.
So, sorry to butt in. I've got another thing I should mention, is that until COVID happened, things were changing. I think even the local manning agents and authorities knew that if they weren't careful, people would stop employing Filipino seafarers. I think industry statistics show that less and less Filipino seafarers are being employed. And it's just not just the cruise industry because of COVID, but I think there's a lot of ship owning companies who are fed up and they're looking at other nationalities rather than top to bottom Filipino. Marina and the Filipino masters unions have written to the government saying, please help, because you're killing our industry. If we're not careful, we will kill our own industry. So, as I said, things are changing. Let's fight. Well, we'll continue to fight. Let's not stop fighting. But once COVID is out of the way, then things should improve.
Let's hope so. Thank you, Costas. Thank you, Holly. Any other questions before we wrap up? You can feel free, if something strikes you in the evening or something that you want to ask a question, email myself and I'll pass it on to Holly and Costas, or email them directly. No problems at all. And like I said, we'll send out some information on the PRM and the PEMI and etc. in the email with the link to this video. If there's no more questions, which seems to be all quiet for now, I'd like to thank Holly and Costas for their time, and for everybody for attending. I know you're all very, very
John,
busy.
we've got a question.
Oh, there's another one. Yeah,
John,
go ahead.
John, good afternoon.
Andreas, how are you?
Hi, fine, thanks. I have a question. What about psychological profile analysis as part of the PMS scheme? Has there been lately any development in this area? Because especially with the COVID conditions lately, there have been incidents of suicide. So, and also in the past, I remember some years ago, we had 2 cases on board our vessel with suicides. And we had a discussion back then with the claims handler. And I think there has not been any progress in this area.
Yeah.
Do you have any comment about this?
Holly deals a lot with this sort of mind call and mind matters as well. Holly, have you got something?
Yeah. Hi, Andrea. Many thanks for your question. It's something we've been talking about recently at the club, and certainly, unfortunately as well, cases of suicide and man overboard incidents have been higher recently. I've been with the club 4 years, and certainly all of the suicides and man overboard I've dealt with have been since COVID. And it is an ongoing question. The difficulty with psychological analysis from our side is that how you're feeling on a day can very much affect your results. So on one day I could do the test and it would be fine, and the next day, if I'm having a bad day, it could be a totally different result. And you could be on that basis keeping away some really good seafarers. On the other side, there are questions as to how easily they can be manipulated and whether someone can falsely give a result so that they can fall through the net, if you like. Another thing we've considered is resilience training and assessment, certainly for officers, and in terms of whether that would be useful. We do have the mine call helpline available to all crew serving on vessels that are entered with the club. If anyone would like the details, I can certainly send that after the webinar. That's not a problem at all. I think a lot of the mental health resilience needs to come from members firstly. Discussions about how you can't improve someone's mental health, but you can signpost as to where they can get help. And I think mental health is something that is being discussed more and more because of COVID, and certainly is something that we're all quite aware of at the moment. And a lot of us suffer from not necessarily poor mental health, but days where our mental health isn't as great as it is, either due to pressures of family, pressures of work. And I can't imagine having all of those problems on a vessel in the middle of the ocean. So the mine call helpline certainly tries to help and provide support to those crew that are suffering from those problems. But certainly linking it back to your question, psychological analysis is something that I think a lot of ship owners are going to have to think about in the future, and whether it is actually worthwhile to you as a ship owner. Costas, I don't know.
I would agree with that. I think I've been asked this question many times over the years, and from the research I have done and spoken with psychiatrists and psychologists, is generally that there's very little that can be detected at PEMI level before they board the ship. More often than not, it's a trigger. Something will trigger them while they're on board, and rather than trying to prevent it before they board, if you can, great. But more often than not, it doesn't happen that way. What we look to is have peer support on board the ship. We know it's a closed society on board the ship. People have to get along. I'm not saying they all have to be best of friends, and they probably won't be best of friends, but they must get along. They're a team. So if it's all possible to make their life better on board, to support them, look for red flags. Somebody sat in their cabin all day long when they're not working, looking up things on the internet, on social media, or looking at films on their own. It's not great. I know people want to be on their own and want to relax and so on and so forth, but if we can make it a better social atmosphere on board, those can help. I'm convinced most of the missing at sea, the seafarers have gone missing at sea during my career have been suicides, but without a witness statement or a suicide note, it's very difficult to do that. And it might just be somebody went out on board on deck for a cigarette and slipped and fell over. We don't know. We'll probably never know. But we all think it's there. And like with Holly, I've seen more people missing at sea this year during COVID than I have beforehand. So those are our suspicions. But I strongly believe, as I said, this has been backed up by what psychiatrists and psychologists have talked about and told me as well when I've asked them, is peer support on board is much more important than trying to detect it beforehand. Holly talked about psychometric tests. We understand some of those in certain areas, whether it's Russia, Ukraine, or even the Philippines, have not changed. They haven't changed in a decade, if not more. I'm not saying they can be faked, but I've heard stories and rumors that because the tests haven't changed, seafarers going to test them are given the results beforehand, or sorry, the questions beforehand and told which answers to opt for. So it's much better to whilst they're on board the ship, to support them that way. And as we said, we do have the Mind Call service as well as the Mind Matters dedicated website to mental health issues as well as fatigue. So I would underline those issues as well.
Thanks, Costas. I know that myself and Holly have had a few conversations with people that do mental resilience trying to see if there's potential for people to not be as mentally resilient as others, but it's quite a difficult thing. So we've done a few tests and we're looking at it, haven't we, Holly? But it's not something that's easy, just sort of like get out of the box and it's a guaranteed fix. So it's taken quite a lot of investigation. Any other questions? No hands going up. Okay, well, again, thank you, everybody. I know you're very busy people, so we appreciate that you came along to listen to us. Thank you, Holly and Costas. And we will be having another webinar next month, probably a cargo-based one, so that I can actually say something. And then I look forward to seeing some of you there. So thank you very much again for your time. Bye-bye.